I too would like to acknowledge the Indigenous people of Australia in the manner that we've heard tonight, with sincerity and with quiet reflection. That happens in New Zealand, and we're getting used to it in Australia, but we've still got a way to go in coming to terms with the wrongs that were done to the First Nations people in our country, and that we didn't really appreciate until people like Colin Tatz came along with views from outside and from his upgrowing in South Africa to show us the light and give us an understanding of the things that were wrong. I would likewise want to acknowledge Colin Tatz. I had the pleasure of knowing him when I was Chancellor of Macquarie University and he was teaching at the university. And thereafter we had many contacts, and I met Sandra and some members of the family, and I came to respect and admire Colin. I had a part in launching one of his books, and I was looking at it today because it had relevance to these remarks of mine, and it showed insight into the issues which I had to come up with and come up to understand in the report that I undertook on human rights in North Korea. We don't have a lot of time, but we're going to divide it very impartially. There's going to be an address for about half an hour, and I've got my watch. It looks as though we're now about 8 o'clock, and after that there will be about a quarter of an hour for questions, and then we'll go home. But I do want to thank the sponsors of this oration, and to say what a privilege and pleasure it is for me to remember Colin Tatz and to be here with all of you and to tell you something about the Commission of Inquiry on North Korea. I can do it readily because earlier today I did an AVL link to Seoul to talk about the change in government in South Korea and what could be done to improve the attention of the government of South Korea to the issues in the Commission of Inquiry report. This is the report. It wasn't published in this way by the United Nations. The United Nations is actually quite efficient and expert in organising commissions of inquiry. But publishing the report and speaking for the report and advocating the report is something that is not done very well. A citizen learning of my work and of this report paid for a considerable number of the report copies, and every time I reach it I ask myself, were you so brilliant in those days? And is this really the work that you feel defines the sort of values that you have felt and expressed in your life? And it is. I knew nothing more about North Korea than the average reader of The Economist newspaper. I knew that it was a very strange country, it was very cut off from the rest of the world, and that it didn't readily allow people to come in, but it did allow very heavily controlled tourist visits. But on those visits you had to be terribly careful, because the slightest hint of disrespect for the members of the Kim family would lead to dire consequences, as Mr. Warmbier, an American student, learned a little later. When asked whether I would undertake as chair the inquiry. I first consulted my partner. I was then in a conference of statisticians, very clever people in England, and so I telephoned him and he said, "What do you know about North Korea?" And I said, "Not much, but that will be a good start, because I will just have to get to understand what is this strange country and what the United Nations ought to do about it." And so we gathered in Geneva in the Palais des Nations on the bank of the lake there, and the three commissioners considered the important issue of methodology of our inquiry. The usual way that UN inquiries are undertaken is the way of the civilian legal system, Napoleon's system, which is more in use throughout the world than the common law Anglophone system, which informs our approach to inquiries in Australia. The commissioners were Marzuki Darusman, who had been the Attorney General of Indonesia, and Sonia Basurko, who had been an activist in human rights inquiries and activities in Serbia. And so we three met in the Palais and we planned our strategy. Because North Korea was so cut off from the rest of the world, we thought that the antidote to this secrecy would be complete openness and transparency on the part of the Commission, and that we would conduct a series of public hearings, because that is the way in Anglophone countries you tend to conduct public inquiries. Think of the Royal Commissions, think of ICAC, and think of other inquiries and how they go about their work. It's all part of that strange approach to openness that was a very important feature of the English legal and governmental system, and has many great benefits for the citizens and people who are subject to it. So the Commission decided we would conduct public hearings, but we then came face to face with the immovable objections of the United Nations. It was too dangerous. They couldn't guarantee our safety. There were very violent people around. They would likely attack us, and it had never been done before, therefore don't do it. And we had a talk about this, and we ultimately decided that the risks were manageable, that we should undertake the investigation publicly, and that we should call for people to come forward if it was safe for them to do so, and those for whom it wasn't safe we saw privately, but as many as possible we saw in public. And we as well organised for video films to record the statements of the witnesses. If they felt able to do so and if it was safe for them, we did it head on. Otherwise, we did it from behind, and they gave their testimony. It was filmed, and it was subsequently uploaded on the UN Geneva website, and it's still there if you wish to investigate our inquiry. The value of doing it this way was that it meant when North Korea said, "You don't know what is really going on, you are biased, you have a hatred of our country and of our supreme leader," we could say, take a look at the investigation and at the testimony of the witnesses. And when they said these are unreliable people who have turned their back on their motherland, we would say, you look at them, and if you can demonstrate to us that in any way they have exaggerated things or given false testimony, then you can invite us to come to North Korea or otherwise arrange for contrary testimony to be given. We arranged with the government of South Korea, and this was a very difficult step, to permit North Korea to have a representative at the inquiry. That took a lot of negotiation because of the security laws and anti-terrorism laws of the Republic of Korea, South Korea. But ultimately they agreed, to their credit. And so we notify, you can arrange for one of your own representatives, or you can arrange for a lawyer to be engaged or some other means of representation. We were determined to demonstrate transparency and openness to the same extent as they were determined to frustrate it and to prevent access and to try to suppress the detail of the complaints and of the great wrongs that they have been doing since the establishment of the Democratic People's Republic of Korea, as it's called, DPRK. And so we had public hearings in Seoul, we had public hearings in Tokyo, where there's quite a substantial Korean expatriate population. We likewise had meetings in London, because in London there is quite a large group of people who served in the armed forces of North Korea who escaped from North Korea, and we had public hearings in Washington, hearings in Bangkok, and we collected all of the data and we then produced our report, and on virtually every page of the report, as is the custom in our type of country, there were passages from the testimony of the witnesses. There's nothing so powerful as the language of people who have suffered and who want to tell the story of their suffering, because it will expiate to some extent the wrongs that have been done to them and their families. And I think this is why, when our report ultimately landed on the lap of the High Commissioner for Human Rights, and then on the lap of the members of the Human Rights Council in Geneva, the report was a sensation. It caused a sensation because they'd never seen a report written in this way. They had had reports written in the third person with no quotes and no passages, no testimony online to back it up. And this was the big difference that we introduced with our methodology. And some, but not many, UN inquiries since have gone about things in the same way as we. The Commission had an agenda, and the agenda was given to us by the Human Rights Council. It required us to investigate a number, 7 major headings, and that we did. We were very methodical. I'd spent so many years correcting judges in lower courts for not expressing their findings and explaining what the evidence was that supported their findings, that I wasn't going to fall into that mistake myself. So right through the report, we have said, we find, and the testimony is this, and the testimony includes this, and the passages would be quoted. And that was the type of report that they'd never received before in the Human Rights Council. But it's the best way to present a believable case, and if you don't believe it, then you have to open your country to allow investigators and the media to come and see whether or not there's exaggeration or error in the reporting. The media attended all of our functions. We were warned not to allow that to, but we overrode that. As well as the witnesses of truth who gave testimony, there were experts and others with specialised knowledge, including specialised knowledge about the international law of genocide and the international law of crimes against humanity. At the end of our investigation, we wrote the report. The first draft was written by officials of the United Nations, and there's always a lot of criticism of the United Nations, but I have to say that the group who were assigned to us, who set up their office in the Salle des Dames in the Palais Wilson, which had been a hotel on the banks of the lake in Geneva, but later became the original headquarters of the League of Nations, and was named after President Wilson. And it's still there in Geneva, Palais Wilson. And so the report was a sensation, because the delegates in the Human Rights Council had never seen anything quite like it. In Geneva, North Korea worked desperately to try to keep the report from being sent on to the General Assembly. They had various manoeuvres, which I won't bore you with, far too tedious, but they were all rejected because of the power of the Commission's report and the way in which it had expressed the information on the suffering that people had undergone. Now, every country has human rights faults. We in Australia certainly have them and have had them. We have human rights wrongs to our Indigenous people, but also to others, to minorities in our country, to women, to people of colour. The White Australia policy was still alive when I was at high school, and the attitude to refugees is a kind of leftover of that attitude that Australia had virtually from the beginning of settlement, of hatred and dislike of people of different skin colour and ethnicity. It's curious to ask why people have this. It seems to be something of an infantile disorder. It's the attitude of little children in infant school of fearing the other. But whatever the reason, it's been a feature of our country and of most countries, and there have been wrongs in all countries. But the question that was posed for us was, is there a case of genocide? Is there a case of crimes against humanity? And if so, what is the evidence to support that, and what should the United Nations do about it? We went through the evidence relating to the Songbun system, which was a procedure by which people were assigned effectively to their career by the government. And if there was any sign of a blemish of disloyalty to the Kim family, they were assigned to work in mines, and they had no opportunity for education and advancement. There was persecution of people because of religious beliefs. There was persecution of women and much suffering on the part of women. There was persecution of those who tried to escape from North Korea across the rivers when they froze in the winter, seeking refuge in China, getting on an escape line, going down to the south of China and escaping into Thailand or into Laos. So all of these elements, the persecution of Japanese abductees who were simply removed from their families and homes and taken to North Korea for the purpose of giving instruction in the latest idiom of the Japanese language in order for spies to be able to do their work in Japan. So all of these findings were made, and they were all in the report, and they were all reported to the General Assembly. North Korea manoeuvred to try to stop the report being passed to the General Assembly, but it was done. And it was done with one of the biggest votes in favour of the General Assembly having it, and that was in favour of opening up North Korea to the gaze of the whole world. And when they did this, it was truly shocking, and the report powerfully demonstrated why that was so. But there was lurking in the background two rather tricky legal questions, and these are really the essence of the matter that I've been asked to address tonight. They were, is this a case of genocide, upon which I had many conversations with Colin Tatz, and or is it a case of crimes against humanity? The natural inclination of knowing of all the suffering and all the wickedness that was visited on the people of North Korea, and particularly in the camps that were set up, denied by North Korea in media statements, but demonstrated very clearly by satellite images, just as the witnesses had told us about. These horrible instances were described vividly in the testimony which was given by people who'd gone through that process, some of whom had to wheel the bodies thrown out of the huts overnight so that they could be picked up in a wheelbarrow and taken to a vat where they were reduced to ashes, but not entirely, because these were people and a regime that didn't have high tech, not at all, and sometimes the wheelbarrow with the ashes had legs and arms, hands sticking out. It was a ghastly part of the testimony, and I have been hardened by years in the law in Australia, and I've seen reports in cases of pretty horrible things, but nothing really prepared me for the testimony of the terrible wrongs that were performed in the name of the Kim family in North Korea. And so instinctually one would say there are a large number of people being killed by that regime, and therefore it is a case of genocide. And there were many human rights organisations which came to us and said, if you don't find genocide in this case, then you've let the system down, because this is a clear case of genocide. But as Colin Tatz said to me in many of the conversations we had about genocide, the way the law of genocide developed from the ideas of Raphael Lemkin was a curious path, and ultimately ended up in a convention, the Convention on the Crime of Genocide, which was adopted in the United Nations General Assembly a matter of weeks after the General Assembly of the United Nations adopted the Universal Declaration of Human Rights. there's a wonderful series of photographs in the Sydney Jewish Museum, and I pay tribute to the wonderful institution that is. But these are photographs of Dr. H.V. Evatt, former Justice of the High Court, the Minister for External Affairs of Australia, who was the President of the General Assembly when both the Genocide Convention and the Universal Declaration of Human Rights were passed through the United Nations and received affirmative votes. In the case of the Universal Declaration of Human Rights, no country voted against it. A small number of countries, including Colin's original birthplace in South Africa, and also Saudi Arabia, voted against the Convention on Genocide, but they abstained on the Convention against human rights breaches. So this was the task we had. We had to look at the definition of genocide. It's interesting to consider this crime because it's one of the two great crimes that came out of the Shoah. Those crimes were genocide and crimes against humanity. There was really no question but that crimes against humanity on the part of North Korea had been demonstrated, but was the extra dimension that Mr. Lemkin had urged, the group crime of genocide, demonstrated in the facts. These are the words of the opening article of the Convention on Genocide. I'm not going to give you a legal lecture, although it is a legal question, but you can consider for yourself the words of Article 2 of the Genocide Convention. In the present Convention, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial or religious group as such. The problem for that definition, as it seemed to the Commission of Inquiry, was that the purpose, the reason, the motivation of the terrible actions of the North Korean regime was not because the people whom they afflicted were being singled out for their race or their ethnicity or their nationality. They were all Koreans, and they in North Korea even laid claim to the Koreans in South Korea. So the issue was, does the absence of a national, ethnical, racial or religious group motivation and the desire to stamp out a particular race, is that met in the evidence that we received? We talked often and long about whether or not it fitted within the definition and whether we were authorised to expand the definition by analogical reasoning. In the end, we did not conclude that it fitted in the definition because the motivation was fundamentally political. It wasn't religious, and it wasn't race, nationality and ethnicity. And on that basis, we were driven to a conclusion that although clearly there were crimes against humanity, equally clearly there was a real problem in squeezing it into the language of the Genocide Convention. And in his book, the latest book that he wrote with Winton Higgins on the dimension of genocide, Colin Tatz emphasised that the rule of international law was extremely important, and it had to be applied to the Armenian genocide and to the Nazi genocide and to all other forms of genocide. Otherwise, you're simply squeezing something else into the language of the kind of great wrong in the international field that Lemkin considered was to be the special attention of the Genocide Convention. And accordingly, at the end of the day of our report, we concluded that we could not squeeze the motivation which is there in the definition of genocide into the case of North Korea. It was even more difficult than that, because the discussions in the travaux préparatoires which preceded the Genocide Convention demonstrated that there were attempts by some of the member states of the United Nations at the time to expand the definition to include the destruction of a racial group in whole or in part for political reasons. The then government of Cuba urged that that additional ground should be adopted. If it had been, it would have been fatal to North Korea, and we would have had no difficulty. But it wasn't. It was opposed by the United States of America. They said, keep it to the great crimes with which we're familiar since the Armenian genocide and the genocide of the Holocaust, and don't expand it any further. And that is what the General Assembly did. There was a reason that was in the back of my mind in coming to that conclusion. Many of the complaints against the United Nations are that the commissions of inquiry and the special rapporteurs in the past have been basically motivated by political instincts of justice and fairness looked at globally. If we are to build the rule of law in the international community, we'll only do that if we build it on a proper, careful and honest approach to the interpretation of the basis of the law. If we're to get to an international community that observes the rule of international law, that is the sine qua non. And so that is what we decided, and that is what we recommended. I think that was another reason why the report of the Commission of Inquiry was a sensation, because in the past there hadn't, I think, been such a Commission of Inquiry which had adopted the text, the context and the purpose of the rule in the Convention as we did. So we had no trouble then moving on quickly to the Convention that lays down the definition of crimes against humanity, and we found crimes against humanity. One scholar, Professor Sharmas of Canada, said, I don't know why the human rights NGOs insist on finding genocide, even though it's not established. It is the gold standard crime, but crimes against humanity are also crimes of great horror and great importance in the United Nations system. And so the crime against humanity is a crime of great brutality done as an act of state and done to inflict murder and other serious crimes upon human beings which shock the conscience of humanity. That's the criterion for crimes against humanity. And there was no doubt that the crimes which we found against North Korea in large numbers met that criterion, shocking to the conscience of humanity, and so we found. So the case of North Korea is an instance of an independent committee of inquiry and great care in the preparation of the report, presentation of the report in a new style and with new techniques. And this is why at the end of the General Assembly's consideration, it was sent up to the Security Council. Only one other report of a Commission of Inquiry has been sent to the Security Council, and that was a report on Burma, Myanmar, Burma. Things were sailing well for action on the report, but at that point Mr. Trump was elected as President of the United States of America. And Mr. Trump felt, as he said several times, quite candidly, that he could get a deal. He was the big expert in deals, and he could get a deal with the Supreme Leader of North Korea. And he went to Singapore, then to Hanoi, and then to Panmunjom, and he believed to the end he could get a deal with Kim Jong-un. But he didn't get a deal. And the net result is that things were set back. They were set back because he went straight, directly and only, to the nuclear problem that North Korea presents to the world. And that is undoubtedly a very great problem. But the way in which diplomacy works, when it does work, is you start on the periphery. You start on the things where you might make progress. You start on things that people will at least talk about. And then you move slowly but surely into the centre where the really hard issues remain. But Mr. Trump knew better, and he went in there, and the net result of it was that South Korea got nothing, the United Nations got no progress, the United States was left with an unsolved problem of growing complexity and danger because of the nuclear stockpile. And this is the situation we are still in today. A great pity that we didn't have some of those very clever people in the State Department with whom I had discussed the matter, talking with us and with United Nations colleagues on how we could start at the periphery, move slowly and gradually through things that could be discussed, and then ultimately and finally getting to the core issues of the greatest danger. So basically that's what I came to tell you about. Is the definition of the crime of genocide still relevant? Of course it's still relevant. Does it cover many cases other than Armenia and the Holocaust of the Jewish people and other victims of the Nazis? Yes, it does. Are there still people who commit crimes against people on the basis of their race, ethnicity or nationality? Sadly, there are. But North Korea was not doing it, doing what it was shown to do, so cruel and against the conscience of humanity on the basis of the race of its victims. They were all Koreans. They claimed that they were their citizens, and therefore that was a bridge too far. So I wish Colin Tatz was here tonight. I wish that he were here to come as a commentator. Colin, what do you think about this? What is your opinion? Can you reason by analogy? Is the fact that Cuba moved for an expansion of the definition and that was rejected, is that relevant? Is it enough that it's a crime against humanity? Do we need to push it against the language into the gold standard crime of genocide? And that is the dilemma of North Korea that I came to address tonight in an oration in honour of Colin Tatz, a great academic, a scholar, and a person of great integrity, a writer of great integrity in his books, and one of the foremost experts on genocide, and one whom I am here tonight to honour as a friend, a colleague, and a great scholar. End of lecture. We now have the lights. Let there be light.